And let me open our participants and watch them as they flow in.
Oh, Sonya and Sara, you guys can leave your videos on while we do the introduction.
Hi, everybody. I want to introduce myself. My name is Christopher Garcia. I'm going to be coordinating the webinar in the background today. And I want to welcome you to SBDC TCA at New Mexico Tech's 4th Annual World Intellectual Property Day celebration. Woohoo! And before we get started, I'd like to go over some webinar ground rules. Everybody on the call right now, you can't share video, so there's not going to be any video of you. So if you have anything, the dogs in the background, don't worry. And there's no audio for you unless you request permission to speak. So don't worry about that. We are going to ask that you put your questions regarding our presentations into the Q&A. And just so I know the Q&A is working, I'd like you to put a hi, hello, how are you into the Q&A for me. And if at any time during the webinar, something's going wrong, you can't hear us, you can't see us, you could always raise your hand. So I'm going to ask my attendees to raise their hands for me. Thank you, Seamus. Thank you, Patrick. Oh, I got a lot of hands. Thank you all. I'm going to lower your hands now. I got a lot of hi, hello, how are yous in the Q&A. So I thank you guys for that. We know it's working. I am going to make sure the chat is working because if you have a technical problem, feel free to chat with me. And I want to make sure that everybody could chat. So if my attendees could chat a hi, hello, how are you into the chat for me, please. Chat is disabled. That's why we do this. I will try to enable chat, but it does not look like it wants to be enabled by me today. Panelists can chat, attendees can chat with the host and the panelist. It should be enabled now. So try chatting. I see some chats coming in. Very good. Chatting again. Perfect. So remember, put your questions for our presenters into the Q&A. Put any questions you have for me about technical issues into the chat. You know how to raise your hand. And I am going to begin recording. If I haven't already, recording is in progress, so we are. And without further ado, I'm going to turn it over to SBDC TCA at New Mexico Tech Center Director, Estefanita Rawlings.
Good afternoon. Welcome. Bienvenidos. And yatahe. Thank you for attending the 4th Annual World Intellectual Property Celebration, sponsored by the New Mexico Small Business Center, the Technology Commercialization Accelerator here at New Mexico Tech. We are here to celebrate World Intellectual Property Day and to bring awareness regarding intellectual property to our small businesses of New Mexico. This year, we have a great lineup. We have representation from the legal arena in New Mexico, Justin Muehlmeyer, and we have the USPTO and the PTRC program. We have Sonya Wright and Sara Butts. You guys can dim your videos for now, and then I'll bring you guys up when it is your time to share. The SBDC TCA here at New Mexico Tech provides these presentations to bring intellectual property awareness to the small business and innovators of New Mexico. My name is Estefanita Rawlings, and I am the Center Director of the New Mexico Small Business Development Center Technology Commercialization here at New Mexico Tech. We provide free confidential counseling regarding intellectual property, which includes patents, trademarks, copyrights, and trade secrets. We have been offering our statewide services for the past 4 years as an SBDC program. This year, we opened up an official SBD center and we are located here in downtown Socorro, New Mexico. World Intellectual Property Day was started in 2000 when the World Intellectual Property Organization, WIPO, member states designated April 26th, the day on which the WIPO Convention came into force in 1970, as the World IP Day, with the aim of increasing general understanding of intellectual property. This year's celebration focuses on building our common future with innovation and creativity. Small businesses are interested in World Intellectual Property Day because it highlights the importance of intellectual property rights and protecting their innovations, building their brands, accessing financing and investment, pursuing global expansion opportunities, and mitigating legal risks. Small businesses often rely heavily on their innovation, whether it's a unique product, service, or process, to differentiate themselves in the market and compete with larger competitors. World Intellectual Property Day emphasizes the importance of intellectual property rights, such as patents, trademarks, and copyrights, which are essential for safeguarding these innovations. By securing intellectual property protections, small businesses can prevent others from unlawfully copying or exploiting their ideas, giving them a competitive edge and ensuring a return on their investment in innovation. For small businesses, building a strong brand and reputation is vital for attracting customers and establishing credibility in the marketplace. Trademarks play a crucial role in protecting brands, logos, and slogans, ensuring that consumers can easily identify and distinguish their products or service from others. World Intellectual Property Day highlights the significance of trademarks in brand building and encourages small businesses to invest in protecting their valuable intellectual assets, which contribute to long-term growth and success. Intellectual property can also enhance a small business' ability to secure financing and attract investment. Investors and lenders often view intellectual property rights as valuable assets that can provide a competitive advantage and generate revenue streams. By celebrating World IP Day, small businesses demonstrate the commitment to protecting their intellectual property, thereby increasing their attractiveness to potential investors and creditors. In today's interconnected world, small businesses have unprecedented opportunities to expand their operations by their domestic markets and reach customers worldwide. Intellectual property rights play a crucial role in facilitating this expansion by providing legal protection for intellectual assets in foreign jurisdictions. World IP Day serves as a reminder for small business to consider international intellectual property strategies and take advantage of opportunities for global growth and expansion. Small businesses face various legal risks and challenges, including infringement claims from competitors, counterfeit products, and unauthorized use of intellectual property by third parties. Celebrating World IP Day encourages small businesses to proactively address these risks by understanding their intellectual property rights, implementing proper enforcement strategies, and staying informed about challenges in intellectual property laws and regulations. By prioritizing intellectual property protection, small businesses can mitigate legal risks and safeguard their assets against potential threats. In summary, small businesses are interested in World IP Day because it highlights the importance of intellectual property rights and protecting their innovations, building their brands, accessing financing and investment, pursuing global expansion opportunities, and mitigating legal risks. By celebrating World IP Day, small businesses reaffirm their commitment to leveraging intellectual property as a strategic asset for growth and success in today's competitive business environment. This year, the SBDC TCA have a great honor of having Justin Muehlmeyer from the Peacock Law Offices, and his presentation will be on top intellectual property issues for small business and startups. We also have Sonya Wright and Sara presenting Getting Started with Patent Public Search. This past year, the United States Patent and Trademark Office rolled out a new application used for prior art search for patents called the Patent Public Search. I thought it would be a great idea to demo and get training on the tool for all the New Mexico innovators and patent seekers out there. Before I hear from our speakers, I would like to let you know about my TCA center here in Socorro. The New Mexico SBD centers fall under the Small Business Administration umbrella, the SBA, the Small Business Administration umbrella, where the SBA is at the federal level, the SBDC is at the state level. We have 19 centers here in New Mexico at the different colleges that help our clients with business startups and sustainability. We have two special programs. One is the International Business Accelerator, located at Santa Teresa, New Mexico. This center provides assistance to businesses needing export assistance. The other program is called the Apex Accelerator, and they provide assistance to businesses wanting to contract with the government. The SBDC TCA Center here at New Mexico Tech provides no-cost confidential counseling to residents of New Mexico regarding intellectual property. The mission of the SBDC is to develop skilled entrepreneurs and strong businesses. Here at the TCA, we like to move our clients forward with their ideas as they work towards commercialization. We provide education and training events to help our innovators learn the process of protecting their intellectual property. Our other role is to provide cybersecurity awarenesses to the small businesses of New Mexico. So thank you, New Mexicans, for coming to this event. Feel free to contact me if you have any questions regarding your idea and moving it forward. We have our meetings via Zoom or in person, whichever is convenient to the client. Now, I would like to move forward with our program. I would like to thank Christopher Garcia from the Valencia County SBDC in Los Lunas, New Mexico, for monitoring this webinar. He will have us all muted until Q&A time, so if you have any questions, feel free to put them in the Q&A. They may be answered by some of the hosts, or they will be answered during the allocated Q&A time. Please note that we are unable to provide legal advice. We will also be recording this event, and the recording will be posted on our YouTube channel. You will also be receiving a copy of the presentations. In return for the presentation, recordings, and handouts, we would appreciate you participating in our survey that will be done during the webinar after our second presentation by the USPTO before Q&A. This survey helps us become a better intellectual property service provider and helps us with our funding. Now, I would like to introduce our first presenter, Justin Muehlmeyer from Peacock Law Office, with his presentation, Top Intellectual Property Issues for Small Business Startups.
Hello, everybody. So since I have 45 minutes here, I'm going to give you a whole crash course as fast as I can to get some of these topics. And I see already someone has asked some questions, and I'll get to those at the appropriate place here. But let me share my screen and we can get going here. All right, can everyone see that?
Not quite yet, but
okay. Can you guys see that?
Yes.
All right. So hopefully by the end of this, you leave it with some of the issues I see with small business in particular and early stage startups, anything regarding IP. Of course, I'm an intellectual property attorney and registered patent attorney. What that means is I can file patent applications and prosecute those before the USPTO for you. But we do all manner of IP at Peacock Law. So the first thing, why is IP important? because it gives you control over something. You don't need permission to do something usually, unless someone else has rights, but IP gives you control over your brand, over an idea, over a creation, and that can be a very valuable tool. It's treated as personal property under the law. It can be assigned and sold just like normal property, and it adds value to your company because of that. The other reason, of course, that you want to care about IP is risk of infringement of other people's rights, because of course other people have rights and you don't want to infringe those. So when we talk about getting permission or license, that's what we're talking about is making sure you're not infringing on someone else's rights. But all those are reasons why you want to understand this stuff, because I have seen, especially at early stage companies, you're at a very sensitive place financially. You don't want to run into these kind of problems. You want to make sure you're thinking about your branding appropriately from the beginning, because if you get ingrained into a brand, you're using it for 10 years, and you didn't take the right steps. I've seen companies run into problems where they've been using something, a trademark, for 10 years. They get a demand letter from someone that's a prior user that's been using it for 15 years, and sometimes you have to rebrand. So these are all very important things to be aware of. So I'm going to talk first very quickly about the 4 different types of IP, and then we're going to start talking about some of the problems I see and specific things of what to do. So there's 4 types of intellectual property. The first big category is copyright. And copyright protects creative works. Works is the statutory term that exist in a tangible form. So if I was just out and about and I sung suddenly, that I don't have copyright in that, even though I creatively sung this song. I haven't recorded it and I haven't written down the musical notation, so copyright hasn't attached yet. But as soon as you put it in a tangible form, whether that's saved on a hard drive, a recording, on paper, copyright technically attaches. Of course, that could be anything from software code to music and lyrics to photos and videos to you name it. So here's the list in the statute of things that are copyrightable. You'll see that there's a list of 8 things here that Congress have addressed so far. And of course, in order to have copyright in something, it has to be an original work of authorship. That means you have to have created it. We'll talk about ownership of copyright a little bit later when it comes to when your employees or independent contractors are working these things or authoring these works. But here's the list. It's literary works, and that's where software falls into that as well, because of course software is just another language. Musical works, that's the sounds themselves as well as the musical work itself in the abstract. I can give a whole hour-and-a-half talk on music law, but that's a whole separate thing. But yeah, so there's the list. And so when you have copyright in something, what does that give you? It gives you the exclusive right to do these 6 things here that you see listed. That's to reproduce, to prepare derivative works, and of course there is an understanding of what that means, to distribute copies. You may ask, well, what's the difference between distribution and reproduction? Well, reproduce means make a copy for yourself. Distribute means to make a copy and give to others. You have the exclusive right to publicly perform this. Of course, there is case law about what it means to publicly perform, because as you imagine, there's a lot of nuance to that. And also to display a work publicly. So those are the 6 exclusive rights that copyright holders have, and whole industries are based on splitting these rights up into various little pieces. You can think of intellectual property as a bundle of rights. Here's the bundle, and they can be separately licensed out, assigned to people to do different things and this and that, even and within fields of use and stuff. It's a big world, and these are the 6 exclusive rights that are bundled up in the world of copyright. So what is not protectable by copyright? Because that really helps you understand what it is. Copyright does not extend to ideas. So just because you wrote a book about a whale doesn't mean you get to stop everyone else from writing a book about whales. in order for them to violate your copyright, they would have had to literally copy the book in a substantially similar way. And that's, that's of course whatever a jury would think that is. So it's a very subjective standard. Of course, courts come up with all the factors of what that may mean, but you never quite know. But yeah, so copyright doesn't protect ideas. It only protects what was expressed in that tangible medium in which it appears. So it's a rather narrow right, and it's not always appropriate. So intellectual property, you often want to think about, because for a particular product, different types of intellectual property may apply. And so that's all part of the strategy that we as attorneys do as well. There is a copyrightable aspect to this, but also, perhaps the most important thing is registering the trademark. And maybe there's a certain function in the product that we want to try to patent, to protect those ideas. But copyright does not protect the ideas. So the next big category of trademark, and this is probably the one where I see small businesses get in trouble the most, is trademark. And so that's names, terms, words, slogans, even sounds used in the sale of goods and services. So you can just imagine, any product has a name that you recognize, and it has value because you as a consumer know the source of those goods and services as recognized through the trademark. Of course, trademark law does not extend to language. You cannot trademark language. So you may ask, well, what's the difference between trademark and language? Well, it has to do with its connection to goods and services and the fact that the word that you're using as the trademark is arbitrary in relation to the goods and services. So, if I sold bananas, I won't have trademark rights in the word banana if I sell bananas, because that's just language. That's called a highly descriptive mark, and it is not registrable or enforceable in any way. And so where I see a lot of businesses have a lot of problems is in these early stages of branding, because a lot of, especially small businesses, they want their trademark to sort of say what they do. Well, that's probably problematic. It's probably not a trademark. So for example, looking at this slide here, this scale here, on one side are things that are not protectable, and those are the descriptive marks. So if you sell computers and you call yourself the computer store, that's not a trademark, and you'll never have exclusive rights in that. On the other extreme are marks that are arbitrary. Those are more likely to be protectable as a trademark, because it's the only reason why, for example, with Apple, the only reason why you might associate the concept of apples as a fruit with computers is because of all the years of branding that Apple, the company, has forced into your mind that association. And that's the kind of intellectual property that a court and the USPTO is more likely to recognize as having trademark rights. Now, of course, in the middle is where a lot of brands exist. Those are called suggestive marks because they suggest what you do but don't literally say it. Those are also often registrable. Depends on how aggressive your USPTO examiner is, or how aggressive the court is in these principles. But in general, those kind of marks are a favorite, especially for small businesses, because if you just had a totally random word as your brand, people may not really, since you're not a famous brand yet, they don't really recognize what you do. So a lot of businesses end up here in the middle. Dairy Queen, even just those words alone may, even if you didn't know it was an ice cream store, has something to do with dairy or treats and stuff. And there's a lot of nuance to this, because in some cases you can register descriptive marks, but it's usually after you have proven distinctiveness with a number of years of use. And so trademark, those rights arise once you're starting to use a mark. And you need to use a mark in order to register a mark. Now, one of the questions had to do with, well, if I've been using it, what rights do I have if I haven't registered? There's actually a bit of some nuance to this. So, for example, in New Mexico, the federal court here has somewhat determined, but not directly, that probably common law rights do not exist in New Mexico. So if you have an unregistered mark, you are probably not going to be able to enforce it in New Mexico. And I've never heard of or seen an unregistered mark being enforced in New Mexico. In this that didn't involve unfair competition. I don't want to get into that now, but yeah, so you want to register your mark. And the reason why the courts here say that there may not be common law rights in New Mexico is because New Mexico has a state trademark act, and it is believed that that basically extinguished the common law rights. So when we say common law rights, that's just a right that given to you by a court. But once the legislature acts to enact a law, the courts can't just make up stuff anymore. And you then must follow the law. And the law says in order to have the benefits of the Trademark Act, you have to register your mark with the state. However, it's pretty rare. We're an IP firm. We do all IP. We don't register state registrations too often. We usually try to go for the federal because the federal registrations, of course, give you those rights nationwide, whereas a state registration only gives you the ability to walk into state court here in New Mexico and enforce your trademark rights. What decides whether you want to get a state registration and a federal registration? Well, a state if you're not using your mark to sell goods and services in interstate commerce, you wouldn't be entitled to a federal registration. So in those cases, say you're a really localized restaurant that, is not near a freeway or something, or like a barbershop, maybe it's just best to register it with the state. But in most cases, if you're coming to an attorney, they're going to highly recommend going for the federal, if you can. We don't have that issue with patent and copyrights because patent and copyrights, they're in the United States Constitution as exclusively federal. So there is nothing the state has anything to do with that. It's only trademark world where you have to think about the division between state and federal because you have both the state and the feds issuing registrations with those. So that's the world of trademark. I see, a lot of clients that are coming to me, especially small businesses and well, even large companies, even with 700 employees and their marketing departments come to me. And, it's pretty common that they have these descriptive marks and I have to have that conversation with them. Look, you really need to be a little bit more creative with your mark here. And especially these days. So a few years ago, the USPTO started to see the most trademark registration applications in the history of all of trademarks. And the reason was that Amazon started requiring all their vendors to have federally registered trademarks in order to sell online. So of course that meant there was a huge rush to go register your trademarks. That was also combined with the pandemic and things becoming more virtual and people closing down their brick and mortar stores and realizing that their online presence and their mark enforcement was really important. And so, to say it bluntly, all the trademarks are taken up. So if you come to me with just a single word and it's a normal word of language, you're probably going to have problems registering it because, of course, you can't register a mark that is confusingly similar with already an existing registration. So you'll want to, these days, you really want to think hard about your branding and be very creative about it. And oftentimes the process when you come to an attorney is, okay, you give us a short list of your favorite marks. We do very quick searches to see, if there's any low-hanging fruit that's clearly a problem. And then we do a comprehensive search where we get a search firm to search all the potentially problematic variations. We review that and give you an opinion as to whether it's registrable or not. And from there, you can decide what to do. The next big category is, of course, patents. Patents can give you the exclusive right to an idea because you can patent processes, articles of manufacture, you can patent a lot of, things that have utility. These are things that work, that function. You can also patent a design, how something looks. For example, the look of a shoe. Those are called design patents. And so you often hear those two different types, design and utility patents. Utility patents have to do with an invention and how it functions and works. Design patents with the appearance of an article of manufacture. But what can you patent? That's anything that's new. That means not, that's the same word as novel. You'll hear the word novel. And that is not an obvious variation of anything done before. So as you can imagine, that's very difficult. The patent process is long and expensive and complicated. It's not really built for small businesses, although we try, but we really try to make sure that you're using your finances correctly here, because everyone gets excited about the patent, but it's a risky investment. And so you want to make sure that you're doing it right and you're doing it for the right reasons, and you're trying to focus on a particular thing that will still have value in the end of the process. But if you get a patent, it's a very powerful thing. You have the right to exclude others from making, using, offering to sell or sell, or importing into the United States what is claimed in your issued patent. It is probably, for that reason, it's the most valuable can be the most valuable of the types of IP, because you're actually protecting the product itself. So those are the exclusive rights with patent. The last big category of IP is trade secrets. There's no process you do to obtain trade secret rights. It's a status of information that you would have to prove in court that you have been keeping this information as a trade secret. What is a trade secret? Well, it's any information that, this is according to the Federal Act, which was which was passed some years ago. But it's information that derives an independent economic value from not being generally known and not being readily ascertainable. That means you can't just reverse engineer it. That kind of information, if you've done whatever you can to keep it secret, a court will recognize that right of you to sue someone for taking that idea. Well, from running with that information, from misappropriating it. They have to actually take it from you. If they come up with it independently, you cannot sue them for misappropriation of trade secrets. That's where patents come into such value, because it doesn't matter if they knew about you or not. You can stop them from doing that if you have a patent. So you can see how these things start to interrelate. One of the downsides of patents, of course, is that you have to tell the whole world what your invention is in order to get these exclusive rights. And sometimes that's not the right course of action, because maybe the valuable thing about your intellectual property is that it's secret and that no one else knows how to do it, in which case you want to keep it as a trade secret. We're often walking, when we're drafting patent applications, we're often walking that fine line of, okay, is that information you really want to include in the patent application? Because if you get a patent, it will be published. And so we're often working through that. So what are the big issues that I see? The first, of course, is ownership. You want to make sure that everything your company is doing, the company owns. That usually means making sure there's written agreements from employees and independent contractors assigning all rights over to the company. Because the goal is maybe one day that your company gets acquired by some other company, or investors invest in it and really expand it. And they want to know that all the efforts that you've put into it are owned by the entity that they're investing in or purchasing. So all the paper trail must line up and show that it is indeed your company. Company name on the top of those employment agreements that says the company owns the IP, and the independent contractor agreements, and of course any other acquisitions you've made over time. So the different types of IP are treated a little bit different for purposes of intellectual property, but what I just said is really the bottom line. You want to make sure this is all in writing. But if, for example, but just talking about copyright, let's use the example of software code. The author of the code, the person that actually wrote the stuff and put it in the tangible medium, is by law the owner. So period. So think about that, and then the other rules start to apply. So if they're an employee, and what is an employee? Well, that is a factual question that can be difficult because even the IRS has a bunch of factors for determining what is an employee, and courts do too, and it can be unclear. But if it's an employee and they created that code in the scope of his or her employment, then the employer by law owns it. But anything outside of employee, that means independent contractors, for example, if you hired a software development firm to develop it for you, even if you paid them, they own that creation unless you have an assignment in writing from them that says that they are hereby assigning all rights in that to you. So be aware of that, because this law used to be different way back, I think, before the 80s, and so there's a lot of misunderstanding about it. So, keep that in mind. Independent contractors are not employees, and they will presume to be the owners of anything they create unless you agree otherwise in writing. Patents, they are owned by the inventors by law, unless, of course, they assign those rights to the company. So same situation. You want to make sure that you get those assignments in writing, either in employment agreements or otherwise, to the company if you intend the company to own. You don't have to do that. You could just have the inventors own, but if there's more than one inventor, that means they both own the whole patent together and jointly, just like married couples in a house. So keep that in mind. That's usually not great for any business. So you tend to want to, because, oftentimes one inventor, did 90% of the work on the ideas and the other 10%. And having two named inventors doesn't respect that sort of division of labor. So you deal with that division of labor in an operating agreement that governs the company and say, okay, well, inventor one owns 70% of the company, inventor two owns 30%, and you have both inventors assign all their rights to the company. And then that way, all the ownership issues are dealt with in the operating agreement, which is the place you want to deal with those kind of things. So those are the ownership issues. The next big issue, of course, is disclosure issues with regard to patents. So so you're only entitled, so in the United States, it is very, well, anywhere in the world, when it comes to inventions and patents, if you publicly use or disclose your invention, or sell a product that embodies your invention, that starts a clock ticking. And if you don't meet the deadlines of that clock, law says that idea is given to the public. So you want to really be careful about who you're telling the details of your invention to. And so, what do I talk about when I'm saying what is a disclosure? Well, be a public use. It could be showing it or describing it on social media, a sale, even a secret sale of an invention has been determined in some cases to be such a disclosure. So bottom line is keep your invention secret until you file a patent application, and get that filed as soon as you can, before you really discuss details with investors, before you really put the word out there about your invention. Now, of course, the patent office won't know about that when you apply for a patent application. So while you are required to disclose to the patent office all the prior publications that you're aware of, these kind of things about you telling people your idea or public use, the patent office won't know about it, and they may very well issue a patent to you, not knowing those things. But when this stuff comes up, especially as in litigation, when you as the patent holder go and sue someone for patent infringement, huge process starts. Not only are they going to try to invalidate your patent, but part of that process is you'll be deposed. They're going to look at all of your online activities during the relevant time, and they're going to say, oh, it looks like you went to that trade show and we have your presentation here and it says everything about your invention that you now claim. And that was more than a year before you filed your patent application. And that could very well end the whole thing and invalidate your patent. Because an issued patent is only presumed valid. It's not the end story. When you get an issued patent, you sue someone for patent infringement, they can invalidate it. And believe me, they're going to spend a lot more time and money searching around for prior art and invalidating references, prior art, to invalidate your patent. They have a lot more time and money to do it and a lot more interest in doing that than the patent examiner, who only had about 10 hours per search to deal with your office action. So keep that in mind. But yeah, so with inventions, if you intend to protect them, keep them secret until you file a patent application. Of course, securing your IP is the next big thing. And one of the questions regarding that, someone asked, what sort of protection can be realistically expected through common law trademark rights? Well, like I said, in New Mexico, it's probably nothing. And so you'll either want to register your trademark with the state or the feds. Copyright, well, you'll hear that, okay, copyright attaches as soon as you put it into a tangible medium. Only a few years ago did the United States Supreme Court say that you actually have to register your copyright before you can sue anybody. So it's pointless. You have to register your copyright before you really have any enforceable rights. So keep that in mind. And there's timelines associated with that. So if you don't do it either before the infringement or within 3 months of publication, you may lose your ability to obtain attorney's fees for a copyright infringement lawsuit. So if there is something, if we're talking about copyright with your IP, you'll also want to register as soon as you can. And of course, patent applications, you don't have rights and inventions unless you file a patent application. So, and it issues as a patent. So keep that in mind. A pending patent application really doesn't give you any rights, essentially. I say that and I don't want you to overreact to what that means, but because it preserves your ability to seek those rights, but until you have an issued patent, you cannot sue someone for patent infringement. So keep that in mind as well. And then if you have information that you consider to be a trade secret, you'll want to do everything you can to keep it a secret. And so that means confidentiality agreements with your employees and independent contractors, physically locking this information if that's what it takes, making sure, anything that you can walk into court with a straight face and say, Your Honor, we've done our best to keep this stuff a secret. And this former employee of mine, he went and took it and to another person or started his own company, and that's a misappropriation. So when we're dealing with trade secrets, we have to, we as attorneys assisting you have to think about, well, what is it in particular that you're trying to protect, and what is the best way to do that? And so, yeah, so that's securing your IP. Okay, so here's a little bit more detail about registering your trademarks. Like we said, you can either do it with the Fed or state. Ideally, you apply to register as soon as you can. It's taken the USPTO now 7 to 12 months to examine a trademark registration application. So in the past, not so long ago, it was about 3 months. So during that time, I would just say, you like your brand idea, let's just file and see how it goes before you really start committing to use it. But now that it takes almost a year to get to examination, you won't know if it's registrable until then. Now we pretty much in all cases do clearance searches before you file. That way you know your risk of infringement by using the mark, and also your chances of success in getting a registered mark. So you'll want to apply as early as you can. You don't have to wait, with the feds at least, you don't have to wait to start using the mark. You can apply before you start using the mark. And then you prove use later before you get the registration. The feds charge, well, and the state, they charge per class of goods and services on government fees, and there's some variations there, but you can expect, about $250 to $350, depending on the goods and services. And like I said, now the feds, it takes about 7 to 12 months, so be aware of that issue. You see we have about 15 minutes. Let me just talk about registering copyright. The Copyright Office is pretty good about providing guidance on their website through what are called circulars. If you go to copyright.gov, you can see circulars, and they tell you, they sort of explain how to register for certain types of things. It can get deceivingly complicated. So if something is of extreme value to you, maybe you come to an attorney first. We show you the structure of how to do it, do the first one for you, and then you can do others after that. But a lot of our clients do this themselves, and the government fee is not high at all. So, but it does take about a year to get examined as well. That's not as important of an issue as it is with trademark, because with trademark, you end up having to rebrand. If you don't end up with a copyright registration on a work, it's less of a concern than you having to rebrand your whole trademark. So trademark rights, don't let those get behind. Really strategize on how you're going to do that before you start heavily investing in your branding. Patent process, it takes years and very expensive. Oftentimes, it starts with filing what's called a provisional patent application, and that's just an informal, unexamined document that's filed with the USPTO. It sets the date by which nothing can be used against you in terms of the patentability of your invention as of that filing date, and then you file. It gives you a year to decide, oh yeah, this is really a good product that I want to continue investing on the patent with. And you file then the non-provisional application within a year of that, and that's the application that ultimately gets examined another year or two after that. On average, you'll see anywhere between 2 and 7 years to get a patent. So you only do it with the stuff that you know that is going to really, it's an invention that is really important to your company that you're going to be doing for a long time, that you don't want competitors to do for a long time. And it's many thousands of dollars, and much even tens of thousands of dollars if you're seeking foreign rights. But yeah, that's a whole workshop in itself. But yeah, you'll want to think about really what is it that you consider your invention. You're the master of your invention. So yeah, you can pay me to invent this for you, but I don't like doing that. You're the person that knows your invention the best. So, give your patent attorney a very good description and figures of what you consider the key features. And from there, they can do a search to see if there's something patentable about it or start to draft the patent application. So that's, the process you want to start preparing for as you're thinking about patents. Yeah, and so feel free to look at those slides later. Now, of course, liability is the other big issue, and that underlies all this. So, because other people have trademark rights, so what do you do about it? Well, like I mentioned, before you really invest heavily in your trademark and your branding, these days I just highly recommend doing a clearance search. It is not that expensive a thing to do. It gives you a good idea of what other prior users of this trademark could be that could cause you a problem, because trademark infringement is a big problem, especially these days. So that's the number one thing I can recommend when it comes to reducing your risk for trademark infringement. Copyright, of course, that's hard. That's harder to avoid risk with. But my recommendation is create your own stuff. Don't take pictures. Don't download photos from the internet and put them on your website. There's a lot of copyright trolls out there that have algorithms that track their photos online, and whenever someone downloads one and puts it on the background page of their website, they get a nasty demand letter demanding, anywhere ranging from $3,000 to $30,000. So avoid those kind of issues. And the place with small businesses I see it the most is their website. And you'll get that demand letter even if you hired someone else to build the website for you. So, and you have to deal with it. So just beware of that. If that does happen to you, talk to your insurance company first. They often can handle those things for you. Patent infringement, even large corporations don't do big patent infringement searches to see what their risk of infringing other patents are. If you know, chances are you already know who your competitors are and what patents they have issued. So, you can search in their portfolio and get a sense of, well, okay, yeah, they have this aspect of this thing patented. That's usually the best way to get a sense of your patent risk. But otherwise, you kind of just have to hope for the best because it is way too big of an ask to do to get a sense of your patent infringement risk by releasing a product. Of course, insurance can help with some of this, but you'll have to talk to your insurance agent about what exactly they cover in terms of these kind of intellectual property risks. Patent infringement is not it's extremely rare that insurance covers that. So keep those in mind. So here's a little summary checklist, but I want to get to some of these questions here. And so you can, of course, go through my slides later and see.
Justin,
some
you
que-
you have 9 minutes, so go ahead we'll give you 5 minutes for Q&A.
Okay. So someone asked, my brand, does that need to be trademark registered? If so, my work is sold everywhere. So would that imply to federally registered? Yes, highly recommend federal registration. If you're selling goods and services across state lines, yeah, apply for that federal registration through the US Patent and Trademark Office. I have another question here. New Mexico, someone says, but New Mexico does not allow municipalities to register a trademark at the state level. That's interesting. I have not run into that. I'm not sure that is accurate because certainly I've represented municipalities before. So, but there is a statute, if I'm correct, that if a state agency wants to register trademarks, there is an approval process. So I think there was some nuance to that question there. Another question here. Let's say I write a paper and sign a copyright release form to the organization that sponsored the conference. I understand I can't sell my paper, but can I give the paper to others? That depends on that agreement you have with the organization that sponsored the conference. Probably the release you gave is not the kind of, it doesn't prevent you from doing other things, but of course it all turns on the details of what's in that document. And so attorneys can't just answer that question without looking at what it was that you signed. Because licensing, like I said, I mean, you can license any small amount especially with publication stuff. You can give one publisher the right to print books. You can have a whole other publisher doing all your electronic digital works. You can have, you can slice this thing up as much as you want. The right to make a movie out of it to another entity and the right to make a show to another entity. It just depends on how you define those contracts. Here's another question. If a company's product is assisting others with development of business plans and capability statements, and that company uses ChatGPT to write text, is that company giving up intellectual property rights? So these kind of issues are still being worked out. But of course, if you did not create something, it's not, so this happens a lot with software companies because software developers often use open source code and incorporate that into their product and this and that. So technically, if a company that has, let's say, code or any creation, and it incorporates the work of others or that was not yours, technically those rights, you do not have rights in those parts of the work. So it gets a little bit nuanced and detailed there. I know a lot of my software clients, for this reason, they even just prohibit their developers from using open source to ensure the sort of quality of the intellectual property. But these days that's pretty much impossible to avoid, because of course all developments develop on other things. It's just a question of to what extent and what you did with it. But yeah, ChatGPT, we don't really know the answer to those things yet. But you can assume that if something like ChatGPT just created it for you, you may not have copyright in it. And I think I answered the other questions. So
There's one that appeared in the chat
oh,
just.
okay.
Can you see it, or would you like me to read it to you?
I can see it. What are your thoughts on laws in other countries that seem to have different rules than US, China, for example? Of course, your foreign rights strategy, it depends on your business goals and your finances and the nature of the invention and the industry. We represent a lot of companies in the mining industry. And of course, there's certain countries where mining is a big deal. And of course, we want foreign rights in those countries. And so, we have a network of foreign associates all over the world that we regularly use to file to obtain patent rights in those countries. So yeah, it's all part of a global strategy. Now, for a small business, it's incredibly expensive to have patent rights around the world. So it's not always the right approach. And yeah, many countries don't have the same respect for intellectual property, or it's just hopeless to imagine enforcing there. But even so, sometimes obtaining or at least preserving your foreign filing rights, it's not a matter of like actually knowing that you're going to enforce your rights in that country. It's a matter of impressing upon potential investors and acquirers of your company that you have done everything you can to preserve whatever rights they think they might need. That's really the reason why you do this often. Because even large corporations, even huge corporations, they're not going into China, into Chinese courts and enforcing patent rights, even if they have a Chinese patent. They do that, of course, but it's less common than you think, and not the real reason why you apply for patents. How does the FTC's recent proposal about non-compete agreements? Oh, it looks like that question got cut off. But I know a lot about that. I'm actually the person updating the employee non-compete treaties in Westlaw that is urgently due here in about a week. But yes, so big news is that non-compete agreements, of course, is a contractual arrangement between two parties or an employer and employee, for example, in which the employee agrees not to work for another competing person or do competing things after the term of their employment. There's been a long debate about the appropriateness of that. It's been a creature of state law because state law, of course, controls contractual arrangements in general. And many states, a number of states have outright banned them. Many states have limited the scope of them and what employers can do in certain circumstances. And so whenever you're talking about non-compete, you always have to look at the particular state law that applies. And of course, even that's a complicated question because you have to look, well, does the employment agreement define it? Or there's all sorts of nuance with these things. So you may not even know what state law applies. But for many, many years, the states have been dealing with answering these questions and passing their own legislation. But this discussion really came to a national debate in years past, especially with the pandemic and low labor availability and all manner of things that have led to this issue of, well, we really don't like non-competes anymore, or at least some people do. It's a very polarized political issue. And the FTC recently issued a final rule after a couple years of issuing proposed rules and reviewing 27,000 comments. They issued just yesterday a rule banning all non-competes starting as of the effective date, which is not for 120 days from when they publish this in the Federal Register, which doesn't happen for, they think, about another week or so. It depends on, it's within the FTC's discretion as to when they actually put it in the Federal Register. So the date of it, though, the effective date will be in early September. But of course, everyone anticipates many lawsuits about this that may issue injunctions that could delay that effective date. So keep an eye out for that, because what this law does is if you have it invalidates existing non-competes with workers that are not senior executives. So for that category of people, you need to give a notice to them by the effective date. So that effective date being in September, my recommendation is just to hold off on giving those notices until we know whether this law is going to be delayed or not.
Justin, I'm
Yep.
gonna have to, can you answer the last one?
Yep. What is the difference between the R mark and the TM mark? The R symbol can only be used with a registered federal trademark. And it helps enhance your damages if you go and sue someone later. TM, you can use that symbol on any trademark, whether it's registered or not, or if it's registered with the state. And that just gives notice to others that you intend to treat this as a trademark. But technically, you don't need to use a symbol with any mark in order to have trademark rights in it.
So Justin, you have been awesome. And I know you didn't get through all your slides, but everybody will get your slides. It is,
Perfect.
we do appreciate you coming in. Thank you guys for all the questions. If we didn't get to your question, we will answer it and send you the answer. So thank you, Justin, if you want to stop sharing.
Yep. Thank you for
You
having
guys
me.
will, everybody will get a copy of is there one last thing you want to say, Justin?
No, I think that's it.
Okay, well, it was so good, such good information, so thank you very much. And
My
now
pleasure.
I would like to introduce Sonya Wright and Sara Butts with a presentation on getting started with the patent public search.
Thank you. I'll share my slides now. And can you see my slides?
We can.
Okay, great. Getting started with patent public search. I'll read a disclaimer to you. References to particular products, patents, trademarks, service marks, services, companies, and/or organizations in this presentation are for illustrative and educational purposes only and do not constitute or imply endorsement by the U.S. government, the U.S. Department of Commerce, the U.S. Patent and Trademark Office, or any other federal agency. The topics that we're going to cover are reasons to conduct a patent search, parts of a patent, introduction to patent public search, layout and navigation in advanced search, search syntax, a multi-step patent search strategy, and additional resources. Let's start with reasons to conduct a patent search. Why do inventors apply for patents? For profit and to enhance their professional reputation, to advance technology, and to show compassion. Let's talk about reasons to search for patents: to get technical information, to understand a historical context, and because businesses may track patent activity of competitors, to explore advancements in technology and find what gaps still remain. And if you're filing a patent application, you may want to do a preliminary patentability search to determine if an invention is new and non-obvious. And you also may search patents to cite prior art in a patent application. Patentability and prior art. A patent may be granted if the invention disclosed is new, useful, non-obvious, and for utility patents, if it's accompanied by a written description disclosing how to make and use the invention. And there are several different types of prior art, for example, patents and patent applications, journal and magazine articles, books, manuals, and catalogs, scientific papers and conference proceedings, websites, and databases. Let's go over the parts of a patent. So on this slide, you can see the front page of a patent. In the top right corner, here's the patent or publication number. We're looking at a patent now, so we can see the patent number in the top right corner, US 9474406. The patent issue or publication date is next. And on this patent, the date of patent is October 25th, 2016. And on the left at the top of the patent, you'll see the title, apparatus with beverage cartridge holder having movable outlet. Underneath the title is the applicant name. Next is the inventor name, and here there are co-inventors. Next is the assignee name, and then further down are with classifications. After the classifications, you'll see the references cited, and then toward the bottom, the abstract, and at the bottom of this front page, you'll see a drawing. Drawing sheets. Drawing sheets or pages of the patent show specific details of the invention. Individual drawings for utility patents will have reference numbers to show the individual parts of each drawing. These numbers are described in the specification. Let's talk about the specification. It has the background of the invention. It has a detailed description of the drawings, preferred embodiment of the invention, and it must be detailed enough that a person of ordinary skill in the art can make or use the invention. In this slide, we can see the claims. So the claims area is highlighted in yellow. It starts with we claim and claim 1. Claims provide the legal protection of the patent. Introduction to patent public search. To get to patent public search, the USPTO search tool, you should go to uspto.gov and then click Find It Fast, which is highlighted in red. And from there, click Patent Public Search, and that's also highlighted in red. And then you'll get to the welcome page, which you see on the right. It says, Welcome to Patent Public Search, and you can select either Basic Search or Advanced Search. Basic Search. On the Basic Search page, there's a quick lookup area and a basic search area. Let's talk about the quick lookup area. In the quick lookup box, you can type a patent or publication number, and publication number means published patent application. So here we have a published patent application number in the quick lookup box. It starts with the 4-digit year 2023. So the number is 2023-006-7609. You'd click search and then scroll down to see the search results. And you can see the search results on this slide. If you click preview, you'll see the front page of the publication. And if you click PDF, you'll see all pages of the publication. Share, print, or download. The URL at the top of the page can be copied and provided to others as a permanent link to the PDF. You can add this link to a text, email, document, or a website. And you can see the URL at the top highlighted in red. And at the top right corner, there are symbols to print or save. And those symbols at the top right are also highlighted in red. Basic search, 2-word search. There are 2 search fields and drop-down menus with a short list of search fields. 1 word can be typed in each search field. So here you can see search at the top, and under search, you see assignee name. And to the right of assignee name is the assignee, Rutgers. And at the bottom, you can see search and inventor name has been selected. And beside inventor name is the inventor, Nosker. Boolean set operator drop-down menu includes and, or, and not. The default operator is and. Proximity operators are only available in advanced search. Search results in basic search. An everything keyword search provides a large number of search results. Preview shows a thumbnail image of the front page. PDF opens in a new browser tab. And web browsers may have print and find on page features. On this slide, you can see at the top right, there are 3 dots. If you click those 3 dots, you could find print and find on page. So some web browsers have that feature. Advanced search features. Select the quick search or enhanced search layout. Quick search and enhanced search are both in the top right corner and they're highlighted in red. And there are 3 databases that are searched by default unless deselected. The databases are in the top middle panel. The gadget function toolbar icons correspond to tabs inside each panel. And the gadget function toolbar icons are in the top left area, and that area is highlighted in red. The Help tab provides additional information such as Boolean set and proximity operators, and field codes and range searching options. And the Help tab is in the middle bottom panel. Gadget functions toolbar. Patent Public Search has 8 functions that appear as a tab in a window pane when activated. These functions are referred to as gadgets. Active gadget buttons are blue. Non-active gadget buttons are white. In this example from Advanced Search, all gadgets have been activated. Selecting a non-active button allows a gadget to be added to a panel. Advanced search options. There are 2 options, quick search and enhanced search, and both of those are in the top right corner. Three databases and 1 search tool. Patent Public Search provides access to 3 databases that can be searched at the same time. USPG Pub is for U.S. pre-grant publications, which are published patent applications since 2001. USPAT is for all issued U.S. patents since 1790, except for the pre-1837 patents that were lost to a fire and never replaced. U.S. OCR is the text of issued U.S. patents from approximately the 1830s to 1970, and they're scanned by OCR. OCR stands for Optical Character Recognition. Overview of search panels. You enter keywords and search terms into search. The search tab is in the middle, in the top panel. The search results tab is in the middle in the bottom panel. The document viewer in this interface is on the right. And in the menu bar at the top of the document viewer, you can click the first button to toggle back and forth between the image view and the text view. Each search will be saved in the search history as a line set number or an L number. And then there is the Help tab to assist you with your searches, and the Help tab is in the lower middle panel. Devices and browsers. Basic search should work with almost all devices used to search the internet, including smartphones and tablets. And it will work with most current browsers, including Safari. Advanced search will not work with smartphones and tablets and will only work with Chromium-based browsers, such as Chrome and Edge. Layout and navigation. Arrange panels. Advanced search can be customized to fit a user's monitor space needs. You can close options and databases menu. So in the interface on the left, in the top left panel, there are options and databases menus, and the options has an arrow beside it, and the databases has an arrow beside it. You can click the arrows to close the options and close the databases. That gives you more room to type your search query. You can adjust or close panels. So if you see the red arrow pointing up, that indicates that you can click the search results and drag them to the top panel. And you can drag gadget tabs from one panel to another. You can see a vertical bar that's highlighted in red. You can drag that bar from right to left to resize the panels. You can move all tabs to one panel and drag your browser window across two monitors. And in the right interface, you can see how the panels look after they have been resized. Navigating with the keypad. Quickly view a set of documents without having to do multiple mouse clicks. Turn on the numlock key on your computer's keyboard, and each key acts as a shortcut as you review documents. Navigating with a mouse. When you select a document in the search results, the text or image of that document appears in the document viewer. In the search results here, the first result is selected. It's highlighted in yellow, and you can see that there's a red arrow pointing to the right. The red arrow indicates that the first result is the one that you see in the document viewer. The document viewer menu bar has arrows to move from page to page and from document to document, and that menu bar is highlighted in a red bar. Search syntax. Search syntax in Patent Public Search. Like written language, search tools have their own syntax. To search a number or word in a specific field, use a field code. The field code should have a period or bracket on both sides, and by bracket, we mean the square brackets. Here are some examples. If you want to search for umbrella in the abstract field, you could type umbrella period AB period. AB is the field code for abstract. And if you want to search for semiconductor in the claims, you could type semiconductor period CLM period or semi-conductor period CLM period. We would want to search for both spellings of semiconductor. Inventor search. The field code for inventor name is period IN period, or you can use period INV period. A middle name or initial may not appear in the patent. Proximity operators. They search for words adjacent or near each other using ADJ or near, within a sentence using with, or in the same paragraph using same. Near with a number after it searches words that are adjacent but in no specific order. For example, Rory period IN period near to Cooper period IN period. That search would search for Rory Cooper in the inventor name area, and it would search for Rory Cooper within 2 words of each other. That accounts for middle names and initials. Assignee search. Inventors may choose to assign or sell patent rights to a company or an institution like a university. The assignee name and inventor names are located on the front page of a patent document. Employees may be required to assign patent rights to their employer if an invention is created using company resources. The assignee name field code is period AS period or period ASNM period. For example, if the assignee is Rutgers, you could use the search statement Rutgers period AS period. And if a company files a patent application, they would be listed as the applicant, and the applicant field code is period AANM period. Patent number search. On this slide, you'll see a chart with patent types, formats, and examples. There are several patent types here: published utility patent applications, utility patents, X patents, which are X patents recovered from the Patent Office Fire of 1836, design patents, and plant patents. Date ranges. Add date ranges to your search using the @ symbol instead of field codes. Search the application filing date by using @AD, and you can search the application filing year by using @AY. Search the patent application or issue date using @PD, and the patent publication or issue year using @PY. You can search with a full date using the 4-digit year, 2-digit month, and 2-digit day, or the 4-digit year. You can search an exact date or year with the equal sign or range using the greater than and less than symbols. Let's go through a multi-step patent search strategy. So the 6 steps are: first, brainstorm terms describing your invention, then conduct a keyword search using Patent Public Search. Next, conduct an in-depth review of the selected documents, and then expand the search to publications with relevant cooperative patent classifications. Next, review cited references, and broaden your search with foreign patents and non-patent literature. Brainstorm terms. When choosing keywords, consider words that describe the nature of the invention, the physical composition, structure, materials, key components, and design, the function or intended use, technical terms, industry terms, and synonyms. And you may miss results that include synonyms, vague technology, vague terminology, and obsolete terms. Let's continue on with our brainstorming. Let's think about the nature of the invention. So let's say you have a product that's a portable charging station for electric vehicles used in roadside assistance. And the physical composition is a DC contactor, converter, coupler, receiver, and a power cable. The function or use is to charge electric vehicles and to provide emergency roadside assistance. And some technical terms, industry terms, and synonyms are portable, mobile, wireless, non-stationary, external energy source, etc. Let's move to our next step, which is the keyword search. Choose possible keywords from your brainstorm, and then add some search syntax, and consider adding field codes. Keyword search results. So we would put our search statement in the top left panel. That's highlighted in red. After clicking search, we would see our search results in the bottom left panel. And the first result is highlighted in blue. It's US 118-90957. So since that one's highlighted, that's the one that appears on the right in the document viewer. And let's say we want to revise our search strategy. So in the search history, you'll see the L number associated with your last search. You can type that L number into the search box instead of retyping the entire search, and then add search terms to refine the search. So let's say that we want to add the term payment. So we could type L1 and payment into our search tab. Let's move to our next step, review relevant results. You can tag documents. As you review search results, you can tag results that are especially relevant. 5 tag columns are automatically displayed, and the settings allows up to 26. Tagged documents can be viewed in the Tagged Documents tab. On this slide, you can see the 5 columns where you can tag documents. The columns are numbered 1, 2, 3, 4, and 5, and they're highlighted in red. Add notes. As you read through a document, you can add a note to the image view. Choose a transparent colored dot and add text. These notes can be viewed in the Notes side panel and in the Notes viewer. So to add a note, you would just go to the image view and then right-click and select Add Note. And you can type the text of the note in the note text box. The next step is to search relevant classification numbers. You can review the front page, and on this slide, we've highlighted the classification areas. Cooperative Patent Classification, or CPC, is a system developed within the European Patent Office for organizing patent documents based on subject matter. CPC went into effect in 2013. U.S. Patent Classification, USPC, is used to organize design patent and plant patent subject matter. Classification. To get to classification, again, you would go to uspto.gov and then click Find It Fast, which is on this slide highlighted in red. And from there, you would go down to classification, and that's highlighted in red, and that will take you to see lots of information about classification. USPTO classification resources. From USPTO's classification resources page, you can search the classification symbol, the text of the classification scheme, or view additional resources to browse the classification scheme. CPC scheme. A classification system is organized by classes and subclasses. It can be helpful to look through the classification scheme to determine what other classes might be relevant. CPC search example. Conducting a classification search may help you find relevant patents that a keyword search would miss. The field code to search CPC classification symbols is $CPC. To search the classification B60L50/00 with any subclass, you could use a wildcard like the asterisk. And if you're going to use the wildcard, you could type B60L53/*CPC. So you can see at the top of this slide, we've typed that classification code, and then we decided to add some keywords and field codes. Espasnet classification search. The European Patent Office provides a patent search tool called Espasnet that includes US and foreign patents. The classification search page is a structured way to view the cooperative patent classification schema, including the ability to expand and minimize classification symbols or do a keyword search of the CPC schema. Step 5, review cited references. On this slide, we've highlighted the area with references cited, and the references cited section will list prior art provided by the applicant and or the patent examiner, including US and foreign patents, patent applications, and non-patent literature. The references that are cited by the examiner will have an asterisk next to them, and the others were sent in by the applicant. Review cited references. Use the document viewer menu bar to search backward and forward citations of a single document. So for citation searching, you would use the quotation marks that are highlighted in red on this slide. And in the full text view of Document Viewer, you can select the metadata icon, which is the icon that is a triangle with 3 dots. And after clicking that icon, you can show US and foreign references by just putting a check in each box. Review cited references. From search results, select relevant documents and right-click to select citations and conduct a search. Note that citation search results in public patent search will include US patent documents, but not foreign patents or non-patent literature. The next step is to search foreign patents and non-patent literature. You can use Espasnet. The European Patent Office has a patent search tool called ESPASnet, and I'll ask Sara to please put this website in the chat for you. ESPASnet allows users to search US and foreign patents, and you can use a pocket guide as a reference to build search queries in the smart search bar, or use the advanced search for a structured search with a drop-down menu. Patent Scope. The World Intellectual Property Organization has a patent search tool called Patent Scope, and I'll ask Sara to put this website in the chat for you. Users can search international patent cooperation treaty applications and patent documents from participating national and regional offices. Search options include basic search, advanced search, field combination search, cross-lingual expansion, and chemical compound search. Frequently asked questions. Can I save my search session? No, at this time, Patent Public Search does not require a login, so it does not have a mechanism to save your search session. Your search session will time out after about 30 minutes of inactivity. Can you print the patents that you find? In Document Viewer, you can print all pages of a single document. In Search Results, Notes Viewer, and Tagged Documents, you can print a chart of results. And in the basic search interface, you can use your web browser's print function to print a table. Can you export your search results? There is not an export feature at this time, but you can select columns and paste them into a spreadsheet such as Excel. And for more on this, see the quick reference guides on the Patent Public Search training materials page. Additional resources. We have our Patent and Trademark Resource Center program, which is a nationwide network of public, state, and academic libraries that are designated by the USPTO to disseminate patent and trademark information and support intellectual property needs of the public. And I'll ask Sara to please put this link in the chat for you. Quick reference guides. If you visit the Patent Public Search welcome page and select training materials, you'll see 10 quick reference guides. Computer-based training. This is the 6-step, multi-step patent search strategy. And this is a computer-based training that includes examples from Patent Public Search. I'll ask Sara to please put this link in the chat for you, in the Q&A, I mean. And Patent Public Search webinars. This is a link which gives you a schedule for our webinars. Getting started with Patent Public Search webinars are offered monthly and are open to the public. And again, I'll ask Sara to put this link in the Q&A. Oh, sure, no problem. We do have micro tutorials, which are on YouTube, and I'll ask Sara to also put this link in the chat for you. Micro tutorials demonstrate frequently used Patent Public Search searches. And for further help, please send an email to psf@uspto.gov. PSF is Public Search Facility. And now I'll go into a live demonstration. So now we're on the USPTO webpage. So you'll go to uspto.gov to get to this page. And then from here, you can go to Find It Fast. And then you can select Patent Public Search. And notice the classification is here at the bottom. That's one of the other places that I mentioned a little earlier. So we'll go to Patent Public Search. And now we're on the welcome page. And from here, you can see the help area. I'll click there. That gives us contact information. And then frequently asked questions. That's another section. And this can be helpful. You can type keywords in the box to help you get to questions that would help you out. And next, training materials. So I'll click there. And here we have the quick reference guides that can assist you as you're creating your search queries. So let's go to advanced search. I'm going to click there. So this is advanced search. And just note that you can change the panels. You can grab this bar and move it up, and grab the bar and move it down to adjust the panels. And you can move the vertical bar from left and right. That allows you to resize panels. So I'll put or search here in the search tab. I'm going to search reflective ADJ leash. Now, the reason I use ADJ is to search for reflective and leash next to each other and in this order. And here are the databases, and they're all selected. So I'm going to click search. And here are the results. So the results show up in this bottom lower area. We have 23 results. And I've highlighted the second result. So that's the one that we see here on the right in the document viewer. We're looking at the text view, but we can switch this to the image view by clicking the first button here in the document viewer menu. And I'm hovering over it now. It says switch to image view. If you want to know what any of these buttons are for, just hover over each one, and then you'll see a message that pops up to let you know what each button is used for. So I'll go ahead and click this first one. Now we're in the image view, and we can see a person holding a leash and walking a dog. I'll go back to the text view. You can open a second document viewer, and the way to do that is to go to the gadgets here at the top, and you hover over each one to see what they're used for. So the magnifying glass is for searching. The calendar is for search history. The papers are for search results. And the question mark is for help. And this notebook is for document viewer. And document viewer is the one that we want. So I'll click the notebook. And then we decide where to put it. We'll put it in the top left panel. And then I will drag down the bar. So now we have both documents side by side. These are the same. We do not have a way currently to have two different documents side by side. So these documents are the same. You may want to have one in the text view and another in the image view. So I can toggle this one over to the image view. And if you'll notice, in the image view, we can see a drawing. And there are several drawing pages in this one, actually. We'll go back to the first page. But in the text view, we're not able to see drawings. And in the text view, you can look at keywords in context by clicking the K, which is here. So once you click the K, you're looking at keywords in context. So we're not seeing the entire document anymore. We only see the part of the document that has keywords, which are highlighted in blue here. I'll go back to our search. The search results help and search history are minimized at the bottom. I'll click search results to bring them back. Okay. If you would like to customize your columns here in the search results, you can. So you can click settings, and then scroll down to see all the choices. And let's say you decide you do not need the document ID, you can just deselect, and then the document ID column goes away, or if you put a check in the box again, then you can see the document ID there. You can also use the print feature. There's a print button here. You would just need to either select specific ones that you would like to print, or you can click select to highlight everything and then just click print. And then you'll see that you'll get a chart that you can print.
Sonia, are these searches confidential, or can the inventor of or the assignee of the patent get a notification that you viewed their design patent?
These are just for issued patents, and these are for published patent applications. So they're all public.
But
Yeah.
the person who submitted the patent doesn't get informed?
No, they
Okay.
don't.
Okay, perfect. Thank you for that.
Sure, no problem. You can add a note if you would like to. Just right click and then click add note. And so here you can type your text. I'm just typing note 1 as an example. And it's red, but let's make it yellow. I'll click yellow and then add. So here's the dot. So the dot can move around. So if your note is about the abstract, you could just move the yellow dot over there. If you do print this page, the dot is not going to be printed. And so there's the print button there in case you want to print. And you can see a list of your notes by going up to the gadgets and then going over to the sticky note, which is for notes viewer. Then we decide where to put it. We'll put it in the top left area, and here's my note. I typed note 1 as the text, and so here it is. And we talked a little about tagging. You can tag documents by putting checks in the boxes beside documents that you want to tag. And tagging is based on your own criteria. You may put a check in column 1 for documents that have an abstract that you think you'd like to look at later. You may put a check in column 2 beside documents that have claims that you want to look at later, etc. And then you can go up to the top to the gadgets. This one is for tagged documents. It's a piece of paper with an asterisk at the top. So I'll click there, and then we'll put it at the top left area. And then all of the documents that I tagged show up here in the tagged documents area. At this time, I'll turn the program back over to Estefanita for a survey.
Sonia, thank you. Sara, thank you for monitoring the Q&A. Sonia, all that information was very, very detailed and very good. I like that you have the slides already. Also, we will answer other questions after we do the survey. As I mentioned earlier, in return for the presentation, recording and handouts, we would like you to participate in the survey. So if you, Christopher has put the survey up on the screen. So if you guys can answer the survey, and we'll give you a couple of minutes, and then we'll come back and have any more Q&A for Sonia and Sara.
Sonia and Sarah, are all the links that you put in the chat available in your presentation, or were there some that we didn't include in the presentation?
Oh, I think you're muted at the moment, Sonia. But I don't mind answering for that. the links are in the presentation. I would say the majority of them, and for the few that might not be, they would be easy to find on the USPTO website.
Thank you, Sarah. Just because I'm not able to copy them from the chat, and I don't want to send out the whole chat because I don't want him to see my technical conversation about chat not working.
Sure, no problem. Would it be easier if I sent what I put in the chat to you, Chris?
If you could send it to me and Steffi, and then Steffi, did you want to send that out in the follow-up email for the
Yes, we can do that. Yes.
Okay.
Okay, thanks.
I want to emphasize the survey. Christopher, has everybody seen the survey?
Everybody should be seeing the survey.
Okay. so-
Although I haven't received a response, just say.
We'll give you guys about 3 or 4 more minutes if you can complete the survey.
I was browsing your YouTube channel, and you sure do have a lot of videos on that YouTube channel, let me tell you. And you have very long tutorials about the topics Sonia covered today.
Yes, hopefully people will find this helpful.
We did have a star client at the SBDC at UNM Valencia campus who must have seen a tutorial like yours, Sonia, and she was actually able to find a invention that was patented in Australia, but not in the United States. And she was able to take that patent from Australia, patent it in the United States, and then create a successful business based on that. So it's
Wow.
worth learning these things.
Absolutely. I agree.
I like that you can add your other screens on that part. I didn't notice that. I hadn't
I
seen it
see.
before. I did take a class before,
Mhm.
so I've been using it some, but now
Oh,
I learned
good.
more stuff, and that's just awesome. That's great.
Great.
Okay, we'll give you guys a couple more minutes. And then also, if you have any more Q&A, put them in the Q&A. Sarah and Christopher have been very successful in answering some of the questions, which has been very helpful.
And when we start our Q&A, I'm going to ask our attendees that if you want to speak, instead of typing your question, to raise your hand, and I will call on you in the order that you've raised your hand. I know some people are typists, so I like to offer that. I don't think we have any phone attendees.
Okay, 1 more minute and we'll wrap it up. And Christopher, will you monitor the hand raising?
I will.
Thank you. Okay, now let's open it up for Q&A. So if you have any questions and you would like to ask them, go ahead and raise your hand or put them in the Q&A box.
I think while we're waiting for questions to come in, Sonya, I think there's a question that we get quite a bit that might be helpful to cover, and that is, can users save their session online when they're searching in Patent Public Search?
Oh, that is a good question. No, at this time, you're not able to save it because there's not a way for you to set up an account. I can share my screen and show you a few ways that you can, for example, copy and paste into an Excel spreadsheet. So I'll just click select and then right click, and then I'll click copy. And then I've just opened up Excel, but you may prefer a different spreadsheet. And then I'll click in Excel and then paste. And here we have the search results that I copied and pasted.
And if anyone is savvy with Excel, you can also format that as a table and sort your table just as you would any other Excel spreadsheet. So you could sort from recent to oldest patent results. You could sort assignees alphabetically. You could sort inventors alphabetically. You can do that in Patent Public Search as well. You can sort the columns by double clicking. We've got a question here. Does the copy to the spreadsheet include links back to search?
No. And what I just did, no, there were not links back to search. No.
We would suggest saving your search strategy. So if you're finding keywords that really work for you, or you find classification numbers that really work for you, it's helpful to write those down, whether you've got a piece of paper and a pen or a Word document open or something of that nature, so you can rerun your search when you go back to it. It says no links back. We've got another question, sorry to clarify. It says no links back to search, but you can edit the search at any time, right? Your active search session, you could edit. Sorry to answer that.
Oh, sure, that's fine.
Okay. I think one cool thing, though, if you want to show them this, Sonya, is the ability to take one of your previous searches and add to it by using the line numbers from your search history. And that's another way to kind of edit your search if you want to expand or refine a search.
Sure. So I just clicked the search history tab, and the search that I did is L1, reflective and leash. So I'm remembering L1, and then I'll go back over to my search tab. And instead of having to type reflective and leash over again, or instead of just leaving it there, I can type L1, and then I can add keywords to this. So I'm building on L1.
So for instance, we could even add a range search to this, like refine the years that we're looking at.
Oh, sure.
So we could, and I would suggest using your help tab for this too, just like Sonya is
Absolutely.
showing you,
Yeah.
because it's helpful. It's in that field code list, even though it's not a field code specifically.
So there's lots of helpful information here. These are the field-specific searches. You can actually click searchable indexes to see a complete list, but the most used indexes are here. And the date ranges are here.
So if we wanted to look at patents issued after 2020, for instance, we
Mhm.
could add the @ PY greater than or equal to 2020.
So there's L1 and @PY for patent or publication year greater than or equal to 2020. Let's go back to the search results. And we have all the databases selected. So we would be searching for published patent applications as well as patents. So I'll click search. And we do get 2 results. And this first one has a D at the front. That means it's a design patent. And the second one is a published patent application. And for the first one, the date published is August 8th, 2023. And the second one, the date published is November 10th, 2022, which is exactly what we were looking for because we searched for patent or publication year greater than or equal to 2020.
Let's see. And then we had another follow-up question. Can the search history also be copied to a spreadsheet? Believe that answer is yes, but there's also a print icon there or a save icon if you want to print a chart of what that looks like or save to PDF. And it'll give you a chart that way, which might actually be a little bit easier for that purpose.
Right.
And then we've got another question that I'll let you take, Sonya. It's someone is asking if the patent search database works similarly to a trademark search.
Well, I would say that there are some differences. Trademarks does have a new search tool. It's relatively new. So there are some differences there. And the trademarks area has some excellent videos on our website to give you training if you're not familiar with their new trademark search tool.
I'll chime in, Sonia, to say that trademark searches are much easier than patent patent searches in my experience.
They are significantly easier. You can definitely get into the nitty-gritty of them, though, if you want to look into their new search language called regex. It does make things a little bit more intricate if you want to go that deep. But most of your trademark searching doesn't need to be that complex. Yeah, I don't think we have any other questions coming in at the moment.
Okay, well, Sara and Sonya, this presentation was very well done. I like the theory on how to do a search and hitting eSpaceNet and the other one you mentioned, the patent scope. I didn't know that one, so I learned something new. Thank you for participating in our World IP presentation, our 4th annual. We will do it again next year. And we look forward to meeting with our new clients. If anybody wants to meet with us, feel free to contact us. And Sonya and Sara, thank you very much for your presentation.
You're welcome.
Thanks so much for having us.
Oh, it was great. Thank you.